Oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-7128, State of Libya appellant versus Strabag SE. Mr. Perla for the appellant, Mr. Byrne for the appellate.
Morning, counsel. Mr. Perla, please proceed when you're ready.
Good morning, and may it please the court. The fundamental defect in this arbitral award is that the tribunal failed to decide an issue submitted by the parties. Who is entitled to keep 98 million euros that Libya advanced to Strabag for work that was never done? Even though the contracts provide for who gets the money, the arbitrators refused to decide the issue because they were worried that if they credited Libya for the advanced payments, Libya might get a double recovery if it later wrongfully called on certain guarantees securing those funds. So what did they do instead? They said, and I quote, "This matter must be addressed outside the context of this arbitration." In doing so, they awarded Strabag, in effect, a double recovery. The arbitrators believed this was acceptable because after balancing the equities and their concerns over the status of the guarantees, they found it was more acceptable for their own sense of good order and fundamental fairness to put the risk on Libya rather than Strabag.
You're focusing on one sentence at the end of that section of the order. But if you read the section in its entirety, they do seem to reject the various grounds that were asserted for the set-off. They say there's no unjust enrichment, there was no misuse of funds, Libyan law doesn't compel this. It seems like they decided it against you. And then they have this aside at the end that had they gone the other way, they would have created a fairness problem. And it might or might not be right, but it sure seems like they decided the issue.
Well, Your Honor, I don't believe that they decided the advanced payments issue, which is ultimately the issue that was before them. Who's entitled to keep this money? And when you look at the entire structure of the section 9 that deals with this issue, it identifies it as the issue of the advanced payment. And then it drops a footnote that refers to the dissent and says this section of the award should be read in conjunction with the dissent. And when you read the dissent, it's criticizing the majority precisely for failing to, and I believe it is, having performed a task partially completed because they had failed to decide the issue of the advanced payments. The majority does not rebut or reject that characterization of what they did in that section. And when you go through it, you realize that nowhere in the section do they say that Strabag is entitled to keep the money. In fact, nowhere in the award do they make that conclusion. And multiple times they say, we're not conducting a global settlement of accounts. We're not doing a wrapping up of who owes what to who ultimately under these contracts. And they focus on the guarantees, which is a very critical point. Their obsession with the guarantees shows that they weren't deciding the issue of the advanced payments, because otherwise, if they had intended to say Strabag is entitled to keep the money, they wouldn't be preoccupied about the guarantees. It would have been clear to the parties that Libya didn't have a right to call on those guarantees. In fact, multiple times Libya throughout the litigation has conceded that if the award had clearly said that Libya was entitled to this money, it would not have a right to call on the guarantees afterwards. And then you have...
So you view that issue to be a closed one, whether Libya has the right to call on the guarantees?
I'm sorry, I didn't hear you.
You view that to be a closed issue, whether Libya has a right to call on the guarantees?
Well, that is a status that is uncertain right now, as the tribunal pointed out, because there is no determination of liability. Who is entitled to those funds? So it remains an issue that must be addressed outside the context of this arbitration, as the arbitrators concluded.
You think the arbitrators contemplate doing anything more when and if this is addressed outside the context of this arbitration?
If I understand correctly, Your Honor, yes, they contemplated that more needed to be done outside the
No,
context.
do they contemplate doing more?
They, the arbitrators?
Yes.
They don't feel like they need to go any further because they believe that after balancing the equities, they couldn't get themselves to say who owed the money to whom. But that doesn't mean...
Which is another way of saying that you all sought a set-off from the arbitrators and they declined to give it to you.
Again, Your Honor, I think the issue is not a set-off. It is who is entitled to keep this money. What do we do about these advance payments that Strabag did not do any work to earn? So this is a real commercial conundrum because it's important to understand that the advance payments were not a signing bonus that they just get to keep from day one. It was a loan to finance the upfront costs of the project. So here they are holding 98 million euros of Libya's money, and there is no determination as to whether they have to return that money, even though they haven't earned it. They haven't done the work, and they've never claimed that they've done the work to earn those funds. But, Your Honor, this brings me to the other point, which is excess of powers.
I'm sorry, which is?
What is
Excess
it?
of powers. Yeah.
Say it again. What?
Excess of powers.
Oh, excessive.
Yes.
Yeah, okay.
So this is the other grounds upon which the award should be
Well,
vacated.
but before you go to that, can I just ask you about a different part of your brief? You say in your brief, and I'm quoting here, that you say the panel's decision is lawless because the majority considered good order and fundamental fairness. But as I read their decision, they only considered fairness after they rejected all of your other legal arguments. So, I mean, how can you call this decision lawless?
Well, Your Honor, lawless in the sense that they didn't rely on a rule of law or a contract
They
provision.
rejected every one of your arguments and then considered fairness at the end.
Well, they rejected reasons for not applying a set-off, but they didn't resolve the underlying issue which was submitted to them, which is the question of the advance payments. And we know that they didn't do that because otherwise they wouldn't have been so preoccupied about the status of the guarantees and Libya potentially getting a double recovery. That issue just would not remain because it would have made it clear that Strabag was entitled to keep that money.
Is there any evidence in the record that that there was a double recovery or even could be? I couldn't find any numbers where I could even figure that out.
Yes, Your Honor.
Where is that?
I can point you to a couple of places. One is the damages section towards the end of the award where the tribunal concludes that Strabag is entitled to get about 74 million euros plus costs and interest. And then in the advance payment section, section 9, I believe it's paragraph 876 or 77, right around there, the tribunal says that Libya paid about 98 million euros in advances that were not earned. Mm-hmm. So if they weren't earned, that means that the money was Libya's money. And if they used the money, as Strabag claims, to buy equipment, to cover costs, to continue running the projects, even though they were getting late payments, that means that Libya has already paid for those damages. So to give them damages for those same expenses on the award is basically making Libya pay twice, once with the advance payments and then again by having to pay on this award. And the problem, in addition to the finality point, is that the tribunal looked to their own sense of good order and fundamental fairness. There was no rule of law that required them to resolve the issue of the advance payments together with the issue of the guarantees. Their mandate was to determine what the parties' rights and obligations were vis-a-vis each other under these contracts. And instead of doing that, they were concerned. They wringed their hands saying, well, we don't know what's going to happen with these guarantees. We can't do anything about that. And because they believed it would be unfair to Strabag, they decided to put the burden on Libya. And that is an excess of powers because when a panel decides an issue based on their own brand of economic fairness rather than the rule of law, it has to be vacated as an excess of power. Now, add a couple points.
You don't think in a contract case, an arbitrator can ask whether or not a particular element of damage would amount to a double recovery?
Yes, but Your Honor, that's not what they determined here. They didn't make a determination as to whether Strabag was entitled to the advance payments and therefore would be subject to, as they put it, double jeopardy, the inverse, if Libya called on the guarantees. And they left open whether Libya would be getting a double recovery if they called on the guarantees after being credited for the monies in the award. So the issue was not, they don't say, are we granting a double recovery and this is why we're avoiding it. They're saying we're concerned that there might be an issue of double recovery. We don't have a way to control for that. So we're going to avoid putting Strabag in the situation of being, Your Honor, I see that my time is up. I can
finish your response.
Okay. We don't want to put Strabag in the situation of being at a disadvantage if Libya were wrongfully to call on the guarantees. So we're just going to avoid the issue altogether and let the parties resolve it somewhere else.
Can I ask you one question, and then we will give you a bit of time for rebuttal. You've, in your briefing and then this morning, you've said several times that there's a difference between the set-off issue and who's entitled to the advance payments. And I'm just wondering, did you ever make that argument in make that distinction and ask for a decision on that in any post-decision submission to the arbitral panel or even to the district court?
Yes, Your Honor, to both. And the issue was clear that the underlying basis for the requested set-off was the advance payments issue. That was the issue that was before the tribunal, and that is what the tribunal focused on. You look at the title of Section 9, and it's not the set-off, it's the advance payment. That is what they knew that they had to decide, and that is what they left open as the dissent note.
But did you point that out? I know you're making the distinction now, but did you submit something to the tribunal? Maybe you did.
Yeah, yes, Your Honor, we did, and I can get you the joint appendix sites on rebuttal if that's
okay.
Thank you.
Thank you. Mr. Byrne.
Thank you. Thank you, Chief Judge Srinivasan, and may it please the court. Libya's argument this morning has asked in a number of ways for this court to essentially displace the findings of the arbitration tribunal, both with respect to the factual findings that it made in reviewing the claims before it, but also with respect to what the issue was before the tribunal. So several times this morning, Libya has indicated that there's a distinction between asking for a set-off and asking for the advance payments. But I would direct this court to paragraph 74 and 880 of the arbitral tribunal's decision, in which it said Libya only requested a set-off, not a counterclaim for unpaid balances. Doesn't go on to talk about asking for the advance payments or the guarantees. Rather, Libya only requested a set-off. So that was the issue that was submitted to the tribunal, and the tribunal resolved it. Libya now concedes on page 13 of its opening brief that the tribunal, quote, specifically denied Libya's request for a set-off, unquote. And Libya further admits on page 6 of its reply brief that the tribunal rejected the particular arguments that Libya advanced in favor of its set-off claim. That, particularly given the deferential standard of review when a court looks at an arbitral award, should be the beginning and the end of this case.
Did they decide, they firmly decided not to order a set-off, as I read it, but they didn't decide whether the letter of credit was still in place, which would enable the double recovery, right?
That's right.
So, I mean, don't they have to resolve that one way or the other? I mean, there's either going to be a double recovery one way or the other, depending on how how you treat the advance payments, right?
No, I don't think that's right. So a couple of points. First of all, the only question before the tribunal was a question of whether Libya was entitled to a set-off from Strabag. And so Libya presented several arguments in favor of why it thought it was due a set-off, either under the terms of the contracts themselves or under the terms of Libyan law, unjust enrichment, so on and so forth. As you said,
suppose the letter of credit had expired. There's no question about that. And the harm to Strabag is whatever it is without reference to the advance payments. I mean, how could you, and that's what's awarded.
Right. So let me help clarify. The reason why there's no double recovery, and I think this is indicated by the tribunal's decision, is that when you're talking about, on the one hand, Libya's claims for damages, and on the other hand, the advance payments to which Libya is referring, these are sort of separate pots of money. These aren't overlapping pots of money. The one way of thinking about it is that, imagine that—
I thought they were advance payments for performance on the underlying
They
contract.
are for performance under the contract, but Libya's claims for damages were on things like, for instance, payment certificates for work that had already been done, and other damages.
No, but forget about any affirmative claims Libya might have asserted but did not. So, just in terms of figuring out what damages your client would be entitled to.
Right. So their claim on the advance payments was premised on the idea that this was money that was sitting out there that Libya had paid to Strabag that had not been used. That was basically sitting in Strabag's pocket. And
right. It's like an advance on performance.
Yeah. And what the tribunal found, and this is I believe at paragraph 900, is that the testimony of the witnesses established to the tribunal's satisfaction that not only the advance payments, but actually substantial additional funds from Strabag had actually been deployed in service of the contract. So this is like a circumstance where, imagine that you hired a contractor to build a home, mm-hmm. and the house costs $100,000. And the contractor is given an advance payment of $10,000 to start work. So work happens for a month. The contractor sends a bill for $8,000 for the work that's been done to date, and it takes out a little bit the proportional amount of the advance payment. But no payment is ever made, and so the contractor then takes the money from the advance payment and puts it towards the work of building the house. It buys the lumber, buys the paint, hires people to do that work. That's sort of the circumstance that we're in now. So our claim was for work that we had already done. Libya is now claiming for the advance payments, but the advance payments have already been employed for Libya's benefit in terms of putting forward the work under the contract, and that's what the tribunal found. And so that's why the district court found there is no double recovery here. The money has already basically been used for Libya's benefit. On the other hand, there really was a risk of double jeopardy to Strabag had the tribunal gone in a different direction, because Libya's witnesses indicated that depending on how the arbitration was going to come out, they were going to call on these guarantees, and the guarantees are, in a sense, a little bit separate from the ultimate, or at least Libya has argued that they're separate from the ultimate question of who gets what under the contract, and so Strabag would have been a real risk had Libya attempted to call on the guarantees. And I think one of the things that the tribunal, which I think was fair for it to consider, after all, Libya is invoking these equitable arguments, unjust enrichment, restitution. One of the things I think that the tribunal appropriately considered is, okay, well, what are the consequences? Would it really be just? Would it really? Is this a circumstance that calls for unjust enrichment and restitution? Those are among the things that the tribunal looked at. But the ultimate question, I think, before this court, isn't whether the tribunal got it right or wrong. It's simply the question of whether the tribunal decided the questions that were before it. This court has indicated that as long as the tribunal is even arguably acting within the scope of its authority, or construing or applying the contract or treated hand, there's no basis to vacate the tribunal's decision, even if this court were to disagree with the tribunal's legal or factual findings. And here we do think that those findings, they were not the product of some sort of material miscalculation or the tribunal's lawless mistrust of Libyan civil servants, as Libya has argued, but rather the tribunal's reasoned analysis of the contracts, the treaty, and the law. And therefore, Libya falls well short of the very heavy burden it bears to show that not only that the tribunal's award, that the district court, which is due deference, that its findings should be reversed, but also that the tribunal's award should be vacant. Are there any further?
I have one quick question just about the issue that's going to come up with the guarantees if it arises. Is it your understanding that the parties disagree on whether the Libya's entitlement to call on the guarantees turns on whether the advance payments were in fact used in furtherance of Libya's interests under the contract?
I don't think that the status of the advance payments is dispositive of what would happen if the guarantees are called for. My understanding of the guarantees is that the guarantees may be called on independent of any legal claim. So in other words, let's say that the contract was going swimmingly, all the work was being done. Libya theoretically could have called on the guarantees, and then there might well be subsequent claims that the parties could bring in against themselves, probably between Al-Hani and Libya, the actual parties to the contract. So I think that that's a separate question, and what happened with the advance payments certainly might bear upon the outcome of that subsequent claim, but I don't think they bear on whether the guarantees themselves could be called. Are there any other questions? Thank you very much.
Thank you, Mr. Byrne. Mr. Perla will give you the 2 minutes that you try to reserve for rebuttal.
Thank you, Your Honor. A couple quick points. One, the counterclaim point, it doesn't resolve the issue of what the arbitrators didn't do, because ultimately they understood that the issue was the advance payments. There's a court of investment treaty arbitrations where a contracting state can't bring a claim. Some tribunals have decided that they can't bring claims under the treaties. But either way, whether it had been styled as a counterclaim or a set-off, the basis upon which the tribunal relied for not deciding the issue of the advance payments would have remained, which, as Your Honors have focused on, is the status of the guarantees. That would have still troubled the tribunal, so it wouldn't have made a difference.
What can they do other than just decide the claims as presented to them? And you didn't bring an affirmative claim on this for that pot of money. You just sought an offset and they denied it.
Again, Your Honor, I think it wouldn't have made a difference if it had been styled as a counterclaim affirmatively or as an affirmative defense in terms of a set-off. The underlying concern about the status of the guarantees would have remained, and the tribunal presumably would have not ruled on the issue just like it didn't in the set-off. And that's important. I think Strabag concedes that these are two separate instruments, the contracts and the guarantees. You don't need to resolve the guarantees to determine liability. Yet it also acknowledges that if you resolve the liability question, then that would have a bearing on whether or not the guarantees could be called on. And before my time is up, Chief Judge, I will give you the sites that I promised you. You can look at JA 856. This is where we talk about the difference between the terms of the contracts and in terms of the advance payments versus the set-off, and also as an example in our reply brief at 5, and I believe also 14, which is not in the record, but it's in the district court. We make the distinction as well. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 20-1121, Sierra Club et al. Petitioners versus Environmental Protection Agency and Michael S. Reagan, Administrator, U.S. Environmental Protection Agency. Mr. Johnson for the petitioners, Ms. Greenfield for the respondents, Mr. Straight for the interveners.
Morning, Council. Mr. Johnson, please proceed when you're ready.
Thank you. Good morning. Seth Johnson for petitioners. I reserve 3 minutes for rebuttal. I regret I'm not able to be there in person. I appreciate your flexibility and particularly the court's staff for accommodating this last minute need for the change in circumstances, I guess. In 2018, this court vacated a portion of a national EPA rule implementing ozone standards because that portion illegally allowed weaker clean air protections. EPA responded in the challenged actions, but rather than actually amend the text of its remaining regulations, effectively invented a new regulation to again allow it to weaken clean air protections. Here, we're challenging EPA's claim that it has authority to terminate clean air anti-backsliding protections in a way its binding national regulations conceitedly bar. After claiming this authority, EPA used it to weaken clean air protections in Dallas and Houston. These areas continue to violate ozone standards through today. As a result, even as EPA terminated clean air protections in the challenged actions and their predecessors, EPA has been slowly inching clean air protections back toward where they had been before EPA weakened them. EPA's actions delay key public health protections. I'd like to begin by addressing our central merits argument. EPA lacks.
Instead, could you begin with venue, please?
Sure.
Let's talk. Yeah, I think all three of us would like to hear about venue first.
Okay. So a principal conclusion of the challenged actions is that EPA has authority, new authority, to terminate anti-backsliding protections in any area by applying 7407 D3E under a revoked standard. That's a principal conclusion of the actions, as I said, and it's nationally applicable action that must be reviewed in this court.
But the rule itself, the title of the rules is all about Texas, Houston, Galveston. The rules themselves expressly say that nothing in this action has legal effects anywhere else, and the technical support documents are just all about full of actual findings having to do with these two communities. That's it.
Well, EPA did take some action that's regionally applicable, but all of that action flowed from.
Let me just finish. And our responsibility here is all we do is look at the face. That's it. Under our case law, right? We just look at the document, and everything on the face of the document says it's locally applicable.
Well, I disagree with that. In the action,
I know you do. I know you disagree, but why?
Right on the face of the action, EPA made a sweeping claim of new authority that it concedes effectively overrides its national regulations. And right on the face of its action, it relied on this court's nationally applicable decision in South Coast 2 to make that claim. Again, right on the face of its actions, EPA did not expressly limit the scope of its claim.
Aren't you? You're now focusing on the notwithstanding clause of the statute, right? You're now saying, okay, this is locally applicable, but it's based on a determination of nationwide scope or effect, right? That's the argument you're making now, correct?
No, I'm still arguing that it's nationally applicable. We do argue in the alternative that even if it's regionally applicable, only regionally applicable, that EPA acted unlawfully and arbitrarily.
Suppose I don't agree with you about the first point.
Okay.
I'd like you to focus on the one issue that I actually think is pretty intriguing in this case, which is your argument that we actually can review the fact that EPA did not make the finding in the notwithstanding clause. It didn't do that. And your argument, as I understand it, is that we can review that as an arbitrary and capricious agency action, correct?
That's correct, just as Judge Silberman said in a concurring opinion.
Okay, well, okay. But this is an issue the court has not decided, correct?
That's correct, yes.
So can I ask you to look at the statute itself? It's got two separate if clauses, right? It says if such action is based on, and then it says and if the administrator finds. So there's two things that have to happen. It has to be based on, and that EPA has to so find. In other words, the way the statute's structured with two if clauses connected by an and, it clearly contemplates the possibility that you could have a locally applicable action that's based on a nationwide scope or effect if the agency chooses not to so find. And what I don't understand is how would we review that? What's the standard we would use to review that as our? It can't be that the action is based on a determination of nationwide scope or effect. It can't be that, right? So what is it?
Well, as this court and other courts have held, the Act has an overall design of centralizing review in this court of actions of nationwide importance. That provides a touchstone along with,
I understand that. Just help me with the language of the statute. Mm-hmm. It's got two if clauses connected by an and. And I understand what you're saying about the purpose of the statute, but this language seems awfully clear to me. So go back to my question. Well, let's assume that I agree with you that this action, based on a determination of nationwide scope or effect, let's accept that for the moment. What standard would the court use to evaluate the agency's failure to make the finding and publishing the finding? How would we do that? What would we say?
The court, well, in this particular instance, I'm going to divide the answer into two pieces here. First is just sort of the general principles of reviewability of administrative action, which put all of the presumptions in favor of reviewability here. This isn't an area where traditionally
accept that.
Okay.
Point accepted.
So the question is whether there is no meaningful standard drawn from the statute and the implementing regulations, as this court has held in numerous cases, by which the court could, measure EPA's action against. And my point is the statute provides a measure. EPA has to provide some explanation of how its decision to or not to direct review to this court is consistent with the overall design of the statute to centralize review in this court of actions of nationwide importance.
But the statute says if the EPA makes such a finding.
Right.
It doesn't require the EPA to make a finding one way or the other. It just says if it makes the finding of national applicability. That suggests that it's free not to make such a finding.
It may be free to not make a finding in particular cases. We asked for it to make the finding, and it provided no explanation whatsoever of its refusal. This is classic agency action where it's just refusing a request. That's reviewable under an arbitrary and capricious standard, I think.
If you ask whether the agency arbitrarily refused to find national scope, wouldn't that necessarily collapse the two prongs into one?
No, I don't think it would. There's
this odd structure to this, as Judge Tatel said. Two things have to happen to trigger the notwithstanding clause. One is that the action must in fact be based on a determination of nationwide scope. And the second is the agency has to so find. If we're reviewing whether or not they arbitrarily refuse to make a finding, we're necessarily reviewing whether or not the decision was nationwide in scope.
I think for the question of, I think there's a different way of looking at this. And this is a way the agency has actually followed. What the if clause does, among other things, is it provides the agency discretion to take an action that's locally or regionally applicable, but make that the underlying determination apply throughout the whole country, even if it doesn't have to. It's done this in administrative actions, and that provides substantial independent meaning for the finding clause. And so I think it's our reading just doesn't collapse them into one. An example of where the agency is
walk me through that a little bit. I mean, the reasoning in the rule is either nationwide in scope or it isn't, right?
Well, the agency provided no reasoning for refusing to make the finding in the.
No, but your theory is the underlying rationale of the rule is nationwide in scope, and that proposition is so obvious that it would be arbitrary to include otherwise.
Yes, that's our principal argument. But if the court, disagrees with that, it could always remand to the agency, because the agency provided no reasons whatsoever for refusing to make a finding. It's never disagreed.
Well, wait, is that right? As I read your comments before the agency, it was that. Correct me if I'm wrong about this. I thought you said that EPA was required under the statute to make a based on finding if the determination was based on. And they responded to that by pointing out that there was a second clause to the statute. Isn't that right?
No, I think they said we didn't make the finding. They never said why they weren't making the finding. They just said we're not making a finding here.
But it said your argument was this is based on nationally applicable rule, and therefore EPA has to make the finding. That's what I read your comment as saying, and EPA responded to that by saying you're ignoring the second clause. It just says if. Am I missing something?
I mean, I disagree. We said there's no lawful or rational basis for it not to expressly find and publish that it's making a finding. It's basing this action on a determination of nationwide scope or effect. And then the agency just said nowhere in the proposal or in this final action did EPA make a finding that the determination is based on a determination of nationwide scope or effect. And therefore the requirements of the statute haven't been met. That's at JA 18. It didn't provide any textual analysis anywhere to back itself up. It's just not providing any reasons for not making a finding it doesn't disagree with. Just epitomizes arbitrariness. Judge Katsas, you were asking me about sort of the mechanics of how the finding clause still has independent effect.
Yeah, because I mean, the only standard, I can easily see a standard for doing this. The difficulty in your position is it's exactly the same standard we would use for reviewing the first clause. And that seems to collapse the two.
I mean, I think
nationwide effect, and the agency says nationwide effect.
There are circumstances where the agency would not have to make a based on finding. I'd refer to 86 Fed Reg 13716. This is a real world example where the agency was asked to review a site specific permit. And it did that. And it said, you know what, we're not going to object to this permit because we're interpreting the statute to say that certain requirements aren't applicable requirements. And in that particular action, the agency said, we like this interpretation so much. We think it's a really good interpretation. We want it to apply across the country. So that's a circumstance where the if clause is totally, what the agency does it's not controlled by the statute. It has discretion to act or not to act. It had to provide a reasonable basis for making that decision. And I think that can be reviewed to see, under standard arbitrary and capricious principles, is there actually something here that could be of nationwide scope and effect? Is the agency's explanation for why it's making this of nationwide scope and effect, is that reasonable under the statute? It's just standard administrative law. And the agency didn't do anything like that here. And so, I think that's a reviewable issue. And if the court agrees, either the court should just reverse it because the agency gave there's no other conclusion the agency could come to other than that it should find and publish that this is of nationwide scope and effect, because of the, because
I don't understand the real world example that you use. I'm not familiar with that example offhand, but as I understand the context, what you're saying is there could be an administrative determination that otherwise wouldn't have nationwide scope or effect, but then the agency can decide that it wants it to have nationwide scope or effect, and so it certifies it as such. And therefore, the second part of this second clause is given effect. But what about the situation in which the underlying determination does have nationwide scope or effect? Then what is it? The statute, there's no standard to determine how the agency is exercising its authority under the second clause of this provision, because it just piggybacks on the first clause. And the agency has to have some independent authority under the structure of the statute, not to make the finding that the action is based on a nationwide scope or effect, even if the finding in fact is.
I mean, if the finding, if the finding may rest on some nationwide scope or some determination of nationwide scope or effect. I'm sorry, if the action may rest on some finding of nationwide scope or effect. I think the agency's obligation to make and publish a finding still serves a purpose. It provides an easy locus for judicial review. It clarifies what the agency is thinking. It makes it easier. And, in a close question where it might be, it might not be, it gives the agency discretion to find that it's not. Here, I don't think we're in that situation, but the court doesn't have to reach that question here, even if the agency has some discretion over whether to make the finding in any given circumstance. It needs to provide reasons. It needs to provide reasons that are linked to the statute. And here it didn't. And I think that necessitates a remand.
Suppose all it said was, in each case where it makes it or doesn't make a determination like this, suppose all the agency said was, in this case, in one case, we want a DC Circuit opinion because it'll be nationally applicable. And in other cases, they say, we're not ready for that. We still want to litigate this in the circuits. Is that enough?
I think it would have to look back to, again, the underlying purpose of the statute.
No. I'm just asking, I'm giving you the hypothetical. You think that wouldn't survive? In other words, if they said in this case, suppose the sentence they added was, this is still a relatively new regulation, and we'd like to litigate this regionally for a while. We're not ready for a DC Circuit decision that would apply nationwide under our regulation. That's the judgment they're making in enforcing this part of the act. Is that not enough?
In some cases, that might be enough. I don't think that would be enough in this case, but in some cases it might.
Well, what more would you want them to say?
I think they would need to. I think it would depend on the particular case. Here, I think they would need to explain how what they're doing, is consistent with their regional consistency regulations, and is consistent with the the centralizing design of the act. I think they would need to provide some sort of explanation that's consistent with the statute.
One more question along these lines, which is, let's distinguish what may be two different agency actions here. One is revoking the backsliding rules for Dallas and Houston. And that's final agency action. That's reviewable. That will be reviewed one way or the other. Mm-hmm. But what we're talking about here for purposes of venue is simply the agency's refusal to make this certification of nationwide scope. Now, why is that final agency action? Normally, final agency action has to have some concrete effect on the parties. And here, the only consequence of that determination is to determine whether you get review in this court or in the Fifth Circuit.
Well, I mean, it certainly is an agency action. I think the question is...
Sure, but finality has not only some element of definitiveness, it has some element of tangible impact on the regulated party.
Mm-hmm. That's an interesting question, Your Honor. It's obviously not one that came up in the briefing.
But it sort of goes to venue, right? You're asking us to review what may not be a final agency action here.
I mean, the agency put it as part of the final action. I think a venue determination may have impacts on, a case outcome, which may have legal impacts, but I
don't know of any cases one way or the other. It may be a question of first impression, but thanks.
I'm not aware.
We will give you some time for rebuttal. Mr. Johnson, we'll give you back the time you asked for, but let me make sure my colleagues don't have additional questions for you at this time. Thank you. Maybe we'll hear from agency counsel now. Thank you, Mr. Johnson.
Yes.
Greenfield.
May it please the court. My name is Megan Greenfield, and I'm here on behalf of EPA. I'll be sharing 4 minutes of my time this morning with Aaron Street for the interveners. The petition for review should be dismissed because venue is proper in the Fifth Circuit, not here. This court held in ARTBA that SIP approval actions, like the ones at issue here, are prototypical locally or regionally applicable actions that are reviewable in the regional courts of appeals. Further confirming that the actions here are regionally applicable, the face of the actions has direct legal consequences only for the Houston and Dallas areas.
Can I just start with the first part of what you said, which is that this is essentially a SIP approval? Because I didn't read your brief to be relying on that, because I was going to ask you some questions about that, but do you think that everything that's being done here is a SIP approval or maybe a SIP modification?
That's a complicated question. It's certainly the case that certain aspects of this action are actions under 42 USC 7410, which is the SIP approval aspect of the act. That includes, for example, the approval of the maintenance plan and also the removal of the anti-backsliding requirement. So we think that those are part and parcel of SIP approval actions, and so they fall within 42 USC 7607B1's express statement and presumption that they're reviewable in the regional circuits.
What else is there? So what is arguably outside of that?
So I think there are other aspects of that, and to be candid, it wasn't fully briefed and developed in the record here what precisely those authorities were, but I can provide further briefing to the court or a 28J letter on that issue.
But I'm just wondering, does the agency, without going into post-argument briefing or anything,
Sure,
for present purposes, does the agency think that the language of the statute that speaks specifically in terms of SIP approvals governs this entire case?
It governs venue for this action. Yes.
Yeah, venue for this,
Yes.
for this,
Yes.
for both of these, for
Yes.
both Houston and Dallas. You think
Yes.
that the first part of the statute, it's clear because it has to be regionally or locally applicable because the statute itself says that SIP approvals are regionally or locally
Right.
applicable.
It creates a
and this is one.
presumption that they are, and these are those. Yes, that's correct.
Why does it just create a presumption? Isn't it more than a presumption, or am I wrong with that?
So I think that there are SIP actions taken under 7410 which are nationally applicable, and those include like actions where EPA bundles together many different actions for different states. Sometimes those are considered nationally applicable, but here where we're speaking to just two specific areas, there's no question that they're regionally applicable.
Okay.
The petitioners argue.
Can I ask you about the argument we were discussing with your opponent there about your position that under the notwithstanding clause, the agency's decision regarding nationally applicable is unreviewable, right?
Right. We think that the Fifth Circuit in the Texas v. EPA case got it right.
Yeah.
And that it's committed to agency discretion by law.
So let me just ask you two things. Is it unreviewable? Let's assume we got a case, two different kinds of cases. Case like a case where the agency says nothing, or a case where it says it is national, it makes the finding. Are both, is that not reviewable either?
This is where there's a difference there. I think if EPA makes a finding that it's nationally applicable, then that is reviewable. But EPA's decision not to make a finding is unreviewable.
It
makes but we're not really reviewing whether or not they made the finding. We're reviewing whether the finding is arbitrary and capricious, right?
Right. In that case,
because of the first prong of
absolutely, you're not
first half of the second, not the notwithstanding clause.
Right. You're not reviewing the administrator's decision to make the finding so much as the finding itself.
Well, not the finding. In a case in which, in answer to Judge Shadle's question, I thought what you said was in a situation in which the action at issue is based on a determination of nationwide scope or effect, and the administrator so finds and publishes. And what would be reviewed, would it be the agency's finding, or would it be whether the action is based on a determination of nationwide scope or effect?
Whether it's based on a determination of nationwide scope.
Right. So there's no daylight between whether the action, in fact, is based on a determination of nationwide scope or effect and the agency's finding to that extent. What's going to be reviewed is the underlying substantive question of whether the action, in fact, is based on a determination of nationwide scope or effect. And of course, the agency is going to have an argument as to why it is, having made the finding, and that argument would have to be taken cognizance of. But I didn't understand your argument to mean that there would be two different things that would be reviewed. There would be one, which is the underlying question of whether the action, in fact, was based on a determination of nationwide scope.
That's correct.
Okay.
So here, the agency was asked to make a finding and it didn't, correct?
That's correct.
So why, explain to me then the difference between that and a situation where it makes the finding and it makes a negative finding on its own?
So,
or would it never do that?
No, the agency's practice is not to make affirmative negative findings that are part of the record.
Okay, just in other words, the agency either remains silent or it makes an affirmative finding, right?
That has been the practice.
That's been the practice.
Right.
I see.
That's correct.
I see. Suppose I don't think this is analogous to prosecutorial decisions. Do you have any other analogies that of other actions that courts have found to be unreviewable that would fit this case? I mean, this doesn't sound like prosecutorial decision to me.
I concede that it is different than prosecutorial discretion, but there aren't criteria in the statute that direct or that a court could review in determining whether or not the administrator made a good decision to find and publish the finding. And the way that the agency has viewed that clause is it allows the agency discretion to determine when it feels that the action is forward-looking, it's going to have a nationwide effect, and wants to direct it to the DC Circuit when it's really making a nationwide policy.
Suppose you have a case where, I realize this is not this case, but you say this is unreviewable, period. Suppose you have a case where there's a pattern. It's totally clear that the EPA is acting arbitrarily. For example, suppose there's evidence that they're making the finding in red states but not blue states. Not reviewable?
So I think that the answer is that the decision not make a finding is unreviewable. I think there's a separate question about whether or not the action itself is nationally applicable. I mean, that is clear that it directs it to this court.
Wait, I lost that.
So
suppose there's 10 cases around the country. We all agree it's based on a nationally applicable standard, but they're only making the findings in blue states and not red states.
I think that would be obviously a much harder case than this one, but I think there too it is unreviewable because there aren't criteria in the statute for the court to examine in determining whether or not the agency made the right call in finding and publishing the determination. And here, just for background, I think it's important to understand why the agency acted the way it did here. So shortly after the 2015 ozone rule was published, EPA took 2 actions applying the redesignation substitute mechanism that was for Dallas and for Houston. And once this court's decision in South Coast 2 came down and vacated the redesignation substitute mechanism, it became clear that those actions were fatally flawed. And so EPA wanted to expeditiously address and replace those fatally flawed actions. And that's why it took the action it did here first before undertaking a national rulemaking. So Judge Tatel, to your earlier question, there's no question at all that here the agency was acting reasonably in taking these regionally applicable actions.
Well, it was taking the same action that it took before our decision in South Coast 2. It's just that after the decision in South Coast 2, the agency decided that it couldn't rely on the same rationale, so it had to redo the rationale. But in other words, the scope of the decision isn't any different than the scope of the decision that was made and that's now pending before the Fifth Circuit.
That's absolutely correct.
It just displaced that other decision.
It just replaced those regionally applicable actions which were challenged in the Fifth Circuit. That's correct. So the agency's action here was based on a new supplemented record,
right,
so that it's more fulsome and reflects the court's criteria in South Coast.
Can I ask a question about reviewability? So the statute says that what the agency can do is that the agency can find and publish that such action is based on a determination. If the agency finds it but doesn't publish it, it wouldn't be, can the agency make the decision, in other words, to make the finding but not to publish it in order to assure that the review of something that does have nationwide scope or effect would be reviewed in a different circuit?
I think that those two, the find and publish, have distinct meaning. That's the Lion Oil case out of the Eighth Circuit, and there EPA had made a decision that was relevant to a specific facility, and it made the finding, it made the affirmative finding, this has nationwide scope or effect, but it failed to publish it. It only gave it to that individual. And so it didn't publish it in the Federal Register or otherwise publicize it. And the Eighth Circuit said, no, this is not, venue is not proper in the DC Circuit. You didn't meet the criteria of the statute because you didn't both find and publish the action. Here, there's no question that the EPA's actions would be published because they're required to be published in the Federal Register. So
is there a reason that the agency would find but not publish? I mean, was that in the Eighth Circuit, was that kind of a mistake?
It was a mistake, yes. And
okay.
we asked in the DC or in the Eighth Circuit, can we please have a second chance and correct it?
Okay.
And they declined. And then
so,
the question.
Another hypothetical. Suppose we agree with you about venue. We could either transfer the case or dismiss the case. Does that make a difference from EPA's point of view?
So it doesn't make a difference here. There is a protective petition in the Fifth Circuit, so you don't need to go through the trouble of transferring. You can just dismiss, and then the Fifth Circuit litigation can begin.
That was a hypothetical.
If you have no further questions, I ask that the petition for review be dismissed.
Okay.
Thank you, Ms. Greenfield. Mr. Street?
Thank you, Your Honor. May it please the court, I'll be very brief on the venue point with two quick points. And the first is just that the way I look at this question is, how would the review that's advocated by petitioners be any different if the first if clause was the only clause in the statute? I don't think they've satisfactorily answered this court's questions on that. And that's precisely what the Fifth Circuit said in Texas versus EPA, quoting from the quote on page 7 of our brief. Sierra Club reading gives no independent meaning to the text conditioning venue on whether the administrator finds and publishes a nationwide determination. Second and final point, of course, subject to this court's questions. I think the argument that the EPA has not given reasons for failing to make a finding illustrates this superfluity point, because the EPA did give a lot of reasons about why this rule was not based on a determination of nationwide scope. And those are the same reasons that it would give about why it did not make the finding. So when petitioner is saying it hasn't given reasons for failing to make the finding, it's because those are the same reasons it gave at JA 17 and 18 for why this was not a rule of nationwide scope or determination.
But did you think that those went to whether it's a determination, that there is a determination nationwide scope or effect, what's on 17 or 18, or did it go to whether the action is nationally applicable?
I think it went to both. I think that's the fair reading of what. If there are no further questions, we'll join in asking that petitions be transferred.
Thank you, Mr. Street. Mr. Johnson, you'd asked for 3 minutes for rebuttal. We'll give you that.
Thank you, Your Honor. I appreciate it. I think the court's questions illustrate that there are potential illegal or arbitrary bases for not making and publishing a finding that the court could adequately review, and that shows that this is not an unreviewable decision. EPA never argued that it wasn't relying on determinations of nationwide scope and effect. Counsel just now said, oh, I think the national applicability arguments apply here too. Dalton Trucking says that those are different findings, different tests. I want to reiterate also that this is a very unusual case. As Ms. Greenfield acknowledged, EPA here was acting in response to South Coast 2, a decision of this court reviewing a nationally applicable rule. The scope of the decision, as Ms. Greenfield said, is no different than it was before. Before, in South Coast 2, EPA had made a decision of, South Coast 2 was reviewing a decision of nationally applicable. And so when EPA is responding to it, it's doing the same thing, similar to what happened in Producers United.
I thought what she was saying was that it's no different from the original action in the Fifth Circuit, Down Ritters, I don't know the name of it, but the one that was brought in the Fifth Circuit on the theory that was regionally or locally applicable. And I thought the argument was that this is just displacing that one, so this one too is regionally or locally applicable.
The agency's actions here constituted also its response to South Coast 2. It applied its response to South Coast 2. It said, oh, our regulation has been vacated. Here's what we think we can do in response to it. And we are applying this where we had previously applied it in Dallas and Houston. And South Coast 2 has to apply nationally. EPA's interpretation of what South Coast 2 also has to apply nationally. That's under its regional consistency regulations. EPA here concedes that it's acting contrary to its currently in effect unamended national regulations. It's effectively overriding or amending them. That must be nationally applicable. Certainly it must be a determination of nationwide scope or effect, one that EPA has never given any reasons for not making. In my remaining time, I just want to make 2 quick points. I would ask for transfer. We filed a petition for a protective petition. There's a little confusion about what day it was filed. We filed it on time. The Fifth Circuit logged it 2 days late. For simplicity's sake, I think if the court did choose to transfer or dismiss, transfer would be simpler and preserve our right to judicial review. I would also note that if the court dismisses or transfers, that confirms that EPA's binding national regulations remain fully in effect throughout the country, including in Dallas and Houston. And I think that's an important point also. If the court has no further questions, I'd ask for vacature.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Thank you.